Bruce Pratt. I'm the president of the Pawnee Business Council, and we're going to start now over there with Adrian, and come down this way and we'll introduce this panel here.
I'm Adrian Spotted Horse Chief, Pawnee Business Council, seat number 3.
I'm Sam Yatson, Pawnee Business Council, seat 1.
Donna here, Pawnee Business Council.
Darrell Wildcat, Vice President, Pawnee Business Council.
Don Mason, Attorney General, Pawnee Nation.
Andrew Knife, Chief Executive Director of the Pawnee Nation. Okay, looks like I'm up. Hope you all bear with me because I'm really under the weather today. But that's okay, I'm getting that out of the way. So, we're going to have a short agenda tonight. What we really wanted to do was just give information to all of our tribal citizens, those that wanted to attend in person, and then those that live outside our jurisdiction that couldn't make it, through recording this and then posting it on the internet and on our webpage and on YouTube. We do this because we understand that our decision to file a lawsuit will have impacts on all of the Pawnee tribal citizens. And first of all, I wanted to say that the Pawnee Nation didn't do this, take this action in haste. This was a deliberate process. This was well thought out. This lawsuit followed 3 summits that we had with our federal partners to try to resolve some of the issues that we outlined in our moratorium that the Business Council passed October 22nd, 2015. We felt as though we weren't going to make enough progress quick enough. The barriers against what we were asking our federal partners to do are just too systemic and too great to break down in a time frame that is, reasonable for us in light of all of the recent earthquakes that we've had here in Pawnee. I think the other day I counted 27 or 28 magnitude 3.0 earthquakes greater in the last 3 months. So the frequency may be going down to some extent from what it was a couple of years ago, but the magnitudes are going up, and that's worrying. When we started this process, we felt as though we had time. After September 3rd, we realized that our clock had begun to toll here on us. We sustained damage to our buildings, and it suddenly dawned on us that, if an earthquake hit the Pawnee Nation, a magnitude of the same or greater, we would suddenly find ourselves looking for a new home. And I found that prospect to be intolerable. We've been displaced from our homeland in Nebraska. We've worked hard to grow our roots here in Oklahoma, a place where certainly my family that I know was all born in. To have to abandon this place because of fracking wastewater or earthquakes, to me was that's something that we as a nation just couldn't sit by and do nothing. So, to give a little history of this lawsuit. This lawsuit actually started to take shape, well, not the lawsuit itself, but the issue started to take shape probably mid-summer in 2015, and culminated in 2015 with the PBC passing a fracking moratorium on Indian Nation or Pawnee Nation land. And this moratorium was, for us, was to ask our federal partners to slow down their activity, take a deep breath, get us involved with consultation, get us involved with all the compliance issues that we may or may not have. and which we didn't know we may or may not have because we never received documentation, or at least adequate documentation. So this led us to ask for summits. You know, we organized the first summit, I think it was in January or February of this year, and it was just basically our staff. You know, it was basically to get all of our division directors together, along with the new Attorney General and the Business Council, to discuss kind of our options, what we're going to do. One thing that came from that meeting was that there were some things that I could do as the Executive Director. There were some things the Business Council could do as the supreme governing body of the Pawnee Nation. And there were some things that, you know, our division directors could do. And so we started to do them. You know, we started taking a more proactive approach to enforcing our environmental regulations within our jurisdiction. Not that we haven't done it in the past. It's just that we had to take a systemic approach because we had no idea the scale or the scope of activity within our jurisdiction. We didn't know where the wells were, we didn't know who was on our land. I mean, we were basically starting from scratch. We had some data, but not a lot of data. And I mainly relied on our Department of Natural Resources and Safety to carry this out. Also help with some of our other divisions like our TERO, our Tribal and Homeless Rights Division. To go out and just kind of, you know, if they see something out there, if they see an activity going on, just let us know where it's at, you know, and, you know, who's on it, who's on the land. Needless to say that was a taxing effort on the part of the nation because we have very limited resources here. Our staff probably consisted total of everybody looking out there, probably 5 people to scour our entire jurisdiction. So it took a lot of energy for us. While they were collecting data, you know, myself and the Attorney General, we went down to the courthouse and we started developing an infrastructure where we could start accepting fines and citations for violators of our environmental laws. And that took us time. It took us time to establish a trust account. It took us time to get the justices briefed up and excited to take on this new challenge because it was a new challenge for our justices. And, you know, I applaud that, you know, the justices at our tribal court because they really, really dove into this project and basically took control. They knew what we wanted, what we were asking of them, and they did everything, you know, and it was great. So now we had a mechanism for our enforcement officers to go out on our tribal allotment lands within our jurisdiction to do inspections, site inspections for compliance with tribal law. Where they found violations, you know, I told them, I instructed my staff to be fair, but to be firm. So if they could correct the problem easily, just, you know, there's no reason to cite them. Just ensure that they correct it. If they didn't feel like correcting it or they didn't want to correct it, well, then that's the time we issue an NOV. And I'm very happy to say that, you know, since we've started this process, you know, we've put a lot of these producers on our lands on notice that we're out there, and they're coming up into compliance. When we first started this process, every day we went to a new job site, our new well pad, we found multiple violations of tribal law, which I should mention mirror, in the most part, federal law as well. So it's not anything that these independent operators or energy companies or whatever should not know or be aware of. While that was going on the administrative side of things, we were also working very diligently to establish meetings with our trust partners. And we did that. Our first one was in February. I think it was the 17th. I can't remember the exact date. But that included a discussion between the Business Council, the Department of Justice, the Bureau of Indian Affairs, the Bureau of Land Management, and the Environmental Protection Agency. It was a good meeting. Everybody was able to kind of outline, our concerns and talk, and we plan on having another one, which we did, with more participation. And then things kind of stonewalled. So we were fortunate enough as a nation to be in Washington, D.C. at the time when we ran into Oklahoma Senator James Langford, who said, hey, if you guys having problems getting people at the table, just let me know. So he did. He got people into the table, so we had our final summit. And again, we felt as a nation that at the time, we had some urgency, but we weren't too concerned. We felt as if we had time on our side. Well, everything changed after September 3rd. September 3rd kind of, I know it changed my mindset. It definitely changed the Attorney General's mindset. I've had many discussions with him. Changed a lot of our tribal citizens' mindset about, what's going on with the oil and gas activity out here. And the Pawnee Business Council basically said, well, we've had enough. So we had been in contact with the Native American Rights Fund and with Earth Justice, helping us write some of this proposed legislation that we wanted to pass, not legislation, but memorandums of understanding or letters of agreement or management plans or whatever that we wanted to try to write with our federal partners. And then turned into, well, how can we go about enforce the hand of the government to take this seriously, take this concern seriously? And that's when we started discussing our options with the lawsuit. So we did. We filed the lawsuit, and that's what brings us here tonight. And this is what Dawn is going to hit some of the particulars of where we are in the process. I want to briefly talk about the lawsuit, what it's asking, what it's not asking. And I think that all of our tribal citizens can see that what we're asking for is pretty fair. It's not unreasonable. So the first issue that we really wanted to discuss in the lawsuit was the trust issue. We were running into a problem with our federal partners where we would find a violation occurring within our reservation lands or within our jurisdiction, and we wouldn't know who to go to report that violation. Go to the BIA, sometimes the BIA would say, well, it's really the BLM's project problem because the BLM deals with everything with pulling minerals out of the ground. Oh, it's an underground injection control. We don't do that. That's the EPA's job. So we just didn't know. We didn't know. And we thought, I think naively a little bit, that we could get some kind of resolve dealing with our local BIA officials to that issue of accountability. Who does the nation turn to? Who does the nation's citizens turn to? More importantly, not just the nation's government, but you all as landowners. If you go out into your fields and you're leasing your land, your family's land and your land to an oil and gas operation, and they are cutting down your trees, taking your water, putting in pipeline and doing all kinds of stuff that you didn't know was going to happen, who do you turn to as a landowner? Do you go to the BIA? Do you go to the BLM? Do you go to the EPA? So in short order, we really figured out fast that this is a problem of the system. It's not clear. I mean, it's clear to us in the language that the ultimate trust responsibility always goes to the Bureau of Indian Affairs, always. But we found out during this process that some of that trust responsibility is also shared with the other federal partners that take the governmental action, whether they're leasing permitting, doing the technical surveys. They also owe the Indian landowners a trust responsibility when they're preparing these documents. So what we found out, though, it was there really isn't anything in place that allows the ultimate trust partner, which is the Bureau of Indian Affairs, to kind of shut down this process at any time if they feel that it's not in the best interest of the Indian, because everything on the federal side is geared towards approval. So if you're a company that wants to do business on Indian land and you submit your application, every mechanism in place at our federal agencies is in place to get that proposed activity approved. So we've had issue with that because we ask, well, is that in the best interest of the Indian? Is that in the best interest of our tribal citizens who own the land? Because what it is it's a fast track to get activity onto our lands. So that was one issue, our trust responsibility. How do we, or who do we go to when we have issues like this? Who is the ultimate decider? Who is the one that will hear our concerns, hear the concerns of the landowners, and put the brakes on the process, or at least slow it down? Because we had no mechanism in place for that. I mean, even our own environmental laws and codes, I mean, because of our unique relationship with the United States government, they don't allow us to do a lot either, except for, fine bad actors or assess license fees, permit fees, and those kinds of things. So the trust issue is number one. The second issue that we had is just compliance with federal law. There is an act called the National Environmental Protection Act, NEPA, and I don't know when that was passed.
1970.
1970. Gotta ask the lawyer. So 1970 that was passed. Basically what that was a document that, or a law that required the federal government to do consultation, not only with local city governments and state governments and all that kind of stuff, but to tribal governments. And the consultation was to ensure that any federal undertaking, and these are just federal undertakings, federal projects, any federal undertaking on land owned by the feds that impact the state of Oklahoma or tribal governments, that we will be notified of the project, that we will have an opportunity to voice our concerns with whether or not there's anything of historic value, cultural value, anything of environmental value, anything that may be impacted in a very significant way. So we can, because we know our land. We know our land. We know our land really well. So it made sense to have us as a consultee for some company that comes into our jurisdiction and wants to build a pipeline, for instance. Makes sense for them to reach out to us because we know our land. And we know every allotment land, every piece of allotment out here has probably a family's burial site. Okay, every allotment land out here has a fireplace, a place where a roundhouse was put on, or an earth. Okay, so we know that these types of cultural and historical things exist within our jurisdiction. And all we asked of the government was to give us the heads up that hey, this is what the project is, this is where it's going. Do you guys know of anything that may be impacted by such a project? And if so, let us know. All right? That's what NEPA was supposed to do. Let us know beforehand the project starts so we can add our voice to the process and guide these companies in the right way so that they're not damaging our environmental resources or even putting our environmental resources in jeopardy or putting our cultural and historical resources in jeopardy. Well, during our tenure, you know, we weren't getting that consultation. We just weren't. Part of what NEPA requires is that there's environmental assessments or environmental impact statements prepared as part of the application process. And I don't want to get too technical here, but a lot of times the federal partners use categorical exclusions to say, well, we don't need to do it here. You know, we're just going to categorically exclude it because it's a general thing or whatever. So what that means is basically we don't get any kind of environmental impact statement or environmental assessment. So our guys who are very capable and very professional can't go out there and assess for themselves whether or not there's going to be any significant or environmental impact on the project. So we, as a nation, are asking in this lawsuit for our federal partners to follow federal law, federal guidelines, and provide us, as a nation, with meaningful consultation. Let us know what you're building, when you're building it, where you're building it, so we can help you come to a determination of whether or not that's in the best interest of the Indian landowner. The third thing that we're asking for our federal partners in this lawsuit is to respect our ability to protect our resources. We are a constitutionally created government. Our Constitution empowers, actually more than empowers, it entrusts our business council with the protection of our citizens and our natural resources within our jurisdiction. And it's a constitutional requirement. And unfortunately, it seems like some on the federal side view their regulations, their policies, as superseding our constitutional authorities. And we disagree. So when we pass a resolution like the fracking moratorium of October 22nd, 2015, because the federal system is set up the way it is, they don't view that resolution as having any more or less authority than let's say if the Pawnee Business Council wanted to, I don't know, pass a resolution to rename a street here. So we, as a government, we disagree with that conclusion. We are asking the federal partners to respect that we are constitutionally entrusted to protect our natural resources for our tribal citizens, not just for our tribal citizens today, but more importantly for our tribal citizens in the future. And with that, that is the did I leave anything else? Okay.
Pretty good outcome.
That's what we're asking for. So what is the lawsuit? How is it going to impact the Indian landowner? I mean, I've probably got some questions about, yeah, I've gotten a few questions about this from tribal citizens as well. The answer is it shouldn't impact the Indian landowner at all at this point. We are at the very early stages of the lawsuit. We just filed it. Don will lay out kind of what to expect and the time, kind of a rough timeline. It's going to take a while. I mean, things don't move very quickly in federal court. So we're looking at a long process. So on the behalf of my office, you know, all I ask of our tribal citizens is be patient. And if you have questions, you know, come see me and I'll give you the best answer I can. Because at this point now, there's going to be a lot of stuff in newspapers and potentially on TV and stuff. And, you know, a lot of it may or may not be true. And, you know, we want our tribal citizens to understand that as of now, this should have no impact on anything that's happening right now. So if you're getting royalty payments, you should be continuing to get royalty payments. If you're getting bonus payments, you should still be getting bonus payments. So that dynamic shouldn't change for our tribal citizens. But it's important to understand that this lawsuit may have consequences should the Pawnee Nation prevail in federal court. Because during this process, we found out that a lot of our lease documents are lease documents that were entered into in the 20s, 30s, and 40s. And they're still active leases. And so once we found out that these leases or these documents still existed, we had questions of them because these documents never, ever imagined a world where people would do a horizontal drilling operation covering 3 miles of land at depths of 12,000 feet or 8,000 feet. Okay, use as much water as they have to use for these fracking cycles, and then take that wastewater and re-inject it back into older, unused wells. These lease documents never, never, never imagine that type of activity. But yet, we are asked, or we are told, basically, that we have to respect that lease. And we find that unacceptable as well. Because the magnitude of the operations, although you don't see as many wellheads in our allotment as we would in the 30s and 40s by these big operations, it's what you don't see. I mean, what you don't see right below your feet that has changed the nature of oil and gas exploration forever. I mean, this technology, while amazing, it just isn't a fit for the language that is contained in the leases that were signed in the 20s and 30s and 40s. Just isn't. Just isn't. So, one of the consequences of this lawsuit, should the nation prevail in federal court, is that those leases would be invalid, which would then force the Bureau of Indian Affairs and our federal trust partners to renegotiate new leases more in line with the modern practice of oil and gas exploration. Now, in my mind, it's a very reasonable thing, right? Others may disagree. I know that some energy companies in our jurisdiction have invested a lot of time and money into their projects. But at this point, we can't be operating off these leases that are inadequate to the scale of operations that are going on. I mean, we have thousands of miles of pipeline that are pushing untold amounts of chemical, and crude oil, and wastewater, and all through our jurisdiction. And these leases never imagined that type of scale of activity, or the impact that activity would have on the environment. Because make no mistake about it, this water that we're pumping into the ground, some of it's going to find its way back up. We had an environmental scientist for the Pawnee Nation do an investigation with contamination on the Black Bear Creek that he ended up way out west of Enid to a tributary of the Black Bear Creek, and what he found was an old rusted out pipe from an old oil and gas operation, and surrounded by underground injection control wells, the wells that push the wastewater in. And the farmer that would own the land said, yeah, he can tell when they're doing the wastewater injection because it gurgles back out of this rusted out pipe from a previous oil and gas operation. And then it just heads right into Black Bear Creek. So, I mean, not all of this water, or not all of this wastewater is going to find its way up, but some of it is. And it's pretty toxic stuff. I mean, it's 10 times more, it's 10 times saltier than the ocean, even. And, it contains all kinds of elements. Not only does it contain the chloride, the salts, the briny water that the oil and gas sits in, but it also contains the chemicals contained to be used for the fracking. It also contains water that's been contaminated through industrial processes from whatever manufacturing, has lead in it, chromium in it, uranium. It's not healthy stuff, and that's why they inject it so deep. They don't ever want it to come up. So that's kind of where we're at as a nation. I want to thank all of our tribal citizens for the patience that have shown myself and the Business Council. They've kept themselves informed. You all have asked the right questions, and hopefully we've been able to give you the right answers. But we as a nation want to also let our tribal citizens know that we're not done yet. We're just getting started with our options to push back. Because what we absolutely have to have here in Pawnee Nation, without a doubt, is we have to have respect for our tribal law by everybody who comes and does business within our jurisdiction. We have to have proper and meaningful consultation so that our guys who are very professional, very well educated, very well trained, can go out and help monitor the activity. Okay. And so that we can protect our cultural, historical, and environmental resources. In my mind, these are very reasonable requests. I don't know what the federal judge in the district court is going to rule. All I know is that we have a very good argument, and that myself and Mr. Mason and our business council and the attorneys working with us, we're going to put our best argument forward, and we're going to fight this thing, and we're going to find other ways to fight it, because we have to stop the activity that is damaging our homes. And again, I always think, especially after the September 3rd earthquake, I thought to myself, if these buildings are destroyed and this groundwater contaminated, where does the Pawnee Nation go? Where do we go? And to me, that is a situation, and that is a future that I cannot tolerate. I just can't tolerate. So that's where we're at. Hopefully we'll continue to have these meetings, not regularly, but when we take an action that we feel as a nation that requires us to give you more information than what we can provide online or through our newsletter or whatever, then we will have these meetings, because we are an open and transparent government. That's something I demand. That's something that the Business Council demands and the President demands. Transparency, so our public, our tribal members understand what's going on. And that's why we record all of these, because we understand that any kind of action we take against oil and gas, or even agriculture activity on our allotment lands, it's going to affect all of our tribal citizens. So we all have to do our part to educate as best we can. So with that, I'll turn it over to Mr. Mason, and he will kind of explain a brief outline of kind of where we're standing and the legal stuff. So thank you.
Andrew did an excellent job of outlining the history of what all has been going on here in Pawnee Nation. I'm here and I'm going to talk about what I call the legal vehicle. Andrew's talked about goals of the nation. What does the nation want? What kind of remedy or remedies does the nation want? And that vehicle is called a lawsuit. Andrew spoke of many meetings, summits with EPA, BLM, BIA. We had many individual meetings, many telephone conversations, a lot of correspondence. And that went over a period of months and months and months. In the legal world, that's called exhaustion of remedy. Because the thing is if you do not exhaust in the eyes of a federal judge your remedy, the judge will simply dismiss your lawsuit or send yourself and the other side packing for mediation, which in the end we may end up having to do anyhow. Alluding to what Andrew spoke of, that is really, a lot of this stuff goes back to lack of respect for the sovereignty of the Pawnee Nation. There's been a consistent, a pattern in practice when it comes to a lack of consultation by any of the federal partners here, BLM, BIA. I consider EPA to be one of those partners. No notice whatsoever, literally have tribal members who wake up in the morning and find a drilling operation, a fracking operation right there in their front yard with no notice whatsoever. And again, the BIA, the BLM, and as far as I'm concerned as well, EPA, all have a trust duty to the people of Pawnee Nation. However, in all these months of summits and meetings, correspondence, telephone conversations, even including staff members of U.S. Senator Jim Langford's office, it always comes back to the same problem. The same problem is that none of these agencies are willing to define what their trust duty is. There is a trust duty there, and I, for myself, and I know Andrew's been sitting there many times, we have asked them to define what it is. And yet they give us a lot of tall talk and lip service, but none of them have been willing to do that. And so in the end, after all this time, as far as I'm concerned, we really, actually nothing has been accomplished. So that was why we ended up concluding that the way to move forward is to sue the BIA and BLM and ask them, what is your duty? And get them before a federal judge. A federal judge will order these people into mediation or into a pre-trial settlement conference, and he will expect these agencies to define what their duty is. And not only that, put the duty on paper and then sign it and put it in the form of an enforceable order before a U.S. federal judge. Now, we filed our lawsuit last week. We, in the legal world, the other side, which is BIA and BLM, they have 20 days to file what is called an answer. Looking at the calendar, they have to have their answer filed by January 25th of 2017. However, also in the legal world, when it comes to the federal courts, what will often happen is the federal judiciary will allow these federal agencies additional time. They'll give them an extension of time. I wouldn't be a bit surprised if the federal judge in Tulsa doesn't do that with BIA and BLM, which means we may not see an answer until late February. Also keep in mind, when they file their answer, they may also file a motion to dismiss. If they do that, then we're going to have to brief the case, file a brief with the federal court, then the judge will read the brief, and then there'll probably be a hearing scheduled at that point. And again, as I've already alluded to, in the federal judiciary, federal judges love mediation. They prefer not to make decisions. They prefer for people to go into a room and for the parties in the room to come to some sort of an agreement with the help of a mediator or an arbitrator. I would not be a bit surprised if in the end the Pawnee Nation does not end up in mediation or arbitration with BIA and BLM. If that happens, you never know what can happen. You may end up getting an agreement in whole or in part. What does you mean in whole or in part? What I mean is you may get a total agreement on all issues. Then again, though, you may get some agreement on some issues. If you do, then that will become part of an order eventually. Those issues you do not agree to, you litigate. And so as you litigate, this can turn into a long journey, a journey of 1, 2, 3 years. As I told Andrew when we filed last week, we're beginning a journey here, and the journey is going to be a long one. And everyone needs to keep in mind about something that is very obvious here. That is, you're dealing with some folks here who have very deep pockets. Because the oil and gas people, they may end up coming in on this lawsuit as well, but Uncle Sam's got deep pockets too. And so this thing could be dragged out for many years. I hope not. I have faith in the system. I've been Attorney General since January. I've worked on this issue just about every day. And I continue to work on it every day. We also, with the help of the environmental department here, daily we continue to document wrongdoings. People coming onto Indian Pawnee land, spilling, injecting, total disrespect for the land, simply cutting down trees, building a road without having the proper easement, and we continue to build a rather large body of evidence. We have the evidence because we've been working on this diligently for so long. And again, as I began my talk, that is, we also have exhausted our remedies. If a judge, that may someday be an objection, but the thing is I feel like that the Pawnee Nation has done everything within their power to bring the BIA and the BLM to the table and to come to some sort of an agreement. And in the end, we after all these months, we still are basically where at least I started back in January. And as Andrew alluded to, in some of the lawsuit I can't comment on because it's considered pending litigation. But not only the trust issues, but inside the trust issues you have some other problems. One is the NEPA, the National Environmental Protection Act. These folks, before they put a drilling rig on a job site, they're supposed to get an environmental assessment. They don't do it. There's a broken law right there. Another thing, there's this thing called the National Historical Preservation Act. Before you go out there and start drilling a oil well, you need to make sure that it's not a protected piece of property. That it's not an Indian cemetery or something of that nature. And believe it or not, I have heard stories where, yes, a drilling rig has showed up in the middle of an Indian cemetery. And then there is the American Indian Agricultural Resource Management Act of 1993. And the Pawnee Nation actually negotiated an agricultural compact with the federal government. And there are sections of that compact in which the federal government have violated even that as well. So, as you can tell, the alleged federal partners of the Pawnee Nation have not been very good partners at all. And in the end, they need to step up to the plate. And in the end, we have reached a point where the only way to do it is to go to federal court. And so that's where we're at. And that's the outline of the legal vehicle of where we want to get with our goals.
Thank you, Mr. Mason. So with that, I'll be more than happy to, and Council, Attorney General, more than happy to answer questions if you all have any. I think I got another microphone.
I have a question.
Yes, sir.
So who is initiating these drilling? Who's initiating the drilling? Is it private? Is it a contract company or is it government?
Oh no, these drillings are all started by private companies.
Okay, so it's a private company. So with that private company drilling in one of our tribal representatives' front yards or backyards or whatever, their land, does tribal police not have any jurisdiction over that land, and can they not implement a trespassing violation, which we have our own judicial system where they can be accounted for in our tribal court?
I'm sure we could.
Okay.
I'm sure that the Pawnee Nation law enforcement could, but we found that to be, in the beginning, overtly aggressive because we felt as though as a nation that we could use the mechanism of the law to resolve any kind of conflict with these the federal partners. See, we don't necessarily want to put the impetus on the private oil and gas companies per se. I mean, we don't want to blame them because we think that this problem can be mitigated directly from the process that the federal government uses to initiate the permitting and the drilling applications from the get-go. I mean, these oil companies are going to come, if they're following the law, they're going to come into our land and they're going to drill. Our issue is we want to change the law. We want our trust agents to understand that before you allow this activity to occur, that you will have meaningful consultation with the Pawnee Nation, with the landowners, that you will ensure that their leases are adequate to cover the type of activity and process that they're saying they're going to do. And to us, that's the real issue. You know, I think by us as a nation, if we were to aggressively approach these producers on our land, then what would happen we would be letting the Bureau of Indian Affairs, the Bureau of Land Management off the hook for their responsibility. And in the end, we can't do that because protesting against the oil company on our land is a short-term solution. Fixing the problem on the federal side ensures that we're going to have a long-term solution so our future generations of tribal citizens will not have to worry about whether or not their leases are relics of the past, whether or not they're going to get notification, whether or not they will be able to have free and informed prior free informed consent, so that when the BIA and the BLM sends information out to our landowners and says, hey, by the way, we have an application for permit to drill, in the future we want our landowners to go, okay, where's our environmental assessment? You know, tell me what is the earthquake risk for this activity? And then our tribal members can make decisions of their own and say, is this worth me signing this document and allowing this activity?
Who grants these permits?
The permits are granted through all three agencies we know. Environmental Protection Agency, Bureau of Land Management, and Bureau of Indian Affairs.
Okay, so these three entities, how many of them are designed to put our tribal people's considerations first?
That's the question. I mean, that's a question we want to answer.
Right there.
That's the problem.
That is the problem right there.
Okay, so as you said, as Mr. Mason stated, that the drilling companies and the government had deep pockets. So in the event, as we're working towards this ultimate goal, you know, if we use our resources that we do have in place right now, whether it be, you know, not the ultimate goal, but a temporary solution to getting to where we want to be, we put them in our tribal courts. They pay fines. They pay whatever it is, violations. And as us, Pawnee, we implement our Constitution if we have, you know, whatever, an amendment that states, like the Osage, that we have these rights, and you have to also obtain a permit from our tribe. Therefore, it can't just be a phone call and I'm coming to drill on your land. We have to have a council of elders, of people who have concern for our people, that say, well, we've overlooked this and we've evaluated this, and ultimately we will not grant your permit. And then if they choose to go, then the tribal police can go in, trespassing. Now it's in our court, money is coming to our tribe, and it's on a hold.
Yeah. We have plans to do all that. I mean, one of our plans, or one thing I'm working on right now is a comprehensive oil and gas statute.
Gas statute we're drafting right now.
And a part of that statute is going to use the full force of the Pawnee Nation on the regulatory side with TARO, with tax, with our Department of Environmental and Conservation and Safety. It's going to use what we already have built in place to go out there and enforce our tribal laws. You know, one thing we won't do, and never do as a government, is tell our landowners that we don't like oil and gas, we don't like guys drilling on our land, so we as a nation are going to outlaw it. Because we understand that our tribal citizens have very few assets, and when they came down to one of the assets they really do have is their land. And they should be able to use their land. Not only that, their children's children should be able to use that land. right? So we understand that our tribal citizens enjoy the use of the lands. And one of the most valuable assets and resources our tribal members have is their oil and gas. And some of our tribal members want to exploit that oil and gas. We're not asking to push these oil and gas activity or oil and gas companies out of our jurisdiction. What we're asking for is A, for the BIA and the BLM to establish a process that's fair to the nation and to the tribal members, and B, a process that encourages responsible energy producers to our jurisdiction and discourages irresponsible energy and gas producers from our jurisdiction. Because there are some, I'm sure there are some good oil and gas operators out there that are willing to consult with tribes, that are willing to go that extra mile for the landowner. It's just that we have too many of them that for so long, they know that when they can come into Pawnee land, they know they can do anything they want to do. And they have.
And that's because we're constantly trying to implement things to eventually bring to surface.
No.
We're not actually acting on these things.
No, because for the most part, we don't get notification of what's going on, so we don't even know where to start looking. Right? I mean, we don't even know what's out there. We do now. I mean, it took us a year, but we've cataloged all of the underground injection control wells, the wastewater disposal wells. It took us about a year. 172 within our jurisdiction.
Mm-hmm. Easier said than done, huh?
Yeah, it is. It's easier said than done.
And with these lands being assets, as I totally agree with that. You know, with the BLM, BIA, and the NEPA, and the National Historic Preservation Act. So let's say that someone comes and drills, and the next thing you know, they leave behind, you know, crude or whatever exposures or toxins that are now a direct health risk to our people. What accountability factor are they going to be following? I mean, what accountability factor do they have to not do that?
And in response to your question, and also in alluding to something you said earlier about tribal court, I would suggest to stay tuned. Because I think if you stay tuned, you're going to start seeing some interesting things happening at our local tribal courthouse.
And is our, which I'm not questioning, I don't know, is the education level of the judge who is head of our court?
Oh yeah,
is he on the level of to be able to obtain his
no problem.
Yeah, not even a question. We have very professional justices. We have they're all experienced attorneys. Most of them have served on tribal courts for a long time, so they're absolutely experienced. And as a matter of fact, when we started this process for enforcing our environmental regulations and developing this process to have a notification of violation and work it through our courts, they weren't concerned with them not having the intellectual or capacity to hear these cases. They were more concerned with the infrastructure that was in place at the time. So they are absolutely professional, and they're absolutely knowledgeable, and they can handle these cases. Yes.
Andrew, and Bobby, thank you for all your comments, Bobby. I like what you said, Andrew, in that in a lot of cases that we just need to slow down a little. And one of the things that I've always kind of questioned was, it seems like year after year, the BIA has, rents out the multi-purpose, and then they have all these leases that they present to the public to take, kind of auction them off. As a landowner, I always wondered, well, where am I in all that? When they're out there and they're bidding against it, and they're taking up leases, I needed to be more educated, as to what is that process really? you know, what are they doing year after year, like creatures of habit? And, you know, what is this doing to ourselves?
Well, I can give you a little bit of background on that because I've researched this about the process. And basically what it is since our land is held in trust for us, you know, our fiduciary, which is the BIA, they're required by law, to have these lease sales, right? Because the federal government wants Indian land to be in production. And whether that's oil and gas, whether that's ranching, whether it's hunting, whatever, that's what they want. So, but the landowner has no part of the process. I mean, that's what we have a superintendent for. Superintendent is there to make those decisions for the landowner. And he's supposed to use the standard of the best interest of the Indian landowner. I mean, oftentimes, the landowners don't even know who's on their lease until they get a letter from the BIA saying that so-and-so has this lease for the next 3 years, here's the terms, blah, blah, blah. You know, because the way the system is set up is that we are wards, for lack of a better term, of the federal government. And so these superintendents at all these agencies are charged with making that decision for you as a landowner. So they go out and they accept all these bids for these lease sales or whatever, and they have a secret bidding, a closed bidding system, and they look at all the stuff that they have to look at due to their policy, and in the end they ask themselves, is this in the best interest of the Indian landowner? If that answer is yes, then they will sign the lease. Indian landowner doesn't know anything until you guys get the notification letter saying that your lease is canceled.
I've been to one of those lease auctions.
That's why we need our own realty department.
Yes, yes,
We are really striving to get a realty department within our nation.
yes,
To handle that.
yes.
Can-
Couldn't hear you. Saying what?
We are trying to get a realty department within the nation.
Yeah.
So that we can take that responsibility from the agency and bring it right in-house. You would be amazed at, I'm sorry, I'm just.
No, you're
But
counsel.
how little money people get for their leases. It's sad. It needs to stop.
Well, that's the deal, is that whenever we get our leases, regardless if it's land, grassland, farming, oil, whatever, it does state that you can disagree with that.
Yeah.
You have a choice.
Yeah.
You could go in there and you can say, Larry Goodfox, who's on that lease? I asked for a description of my mom's land at Oto in writing. And about 3 weeks later, I got a package that thick. There was almost 400 shares of that one parcel of land that was Oto's.
Yeah, you do have.
Now, you have a right.
You do
Whenever
have.
those leases come in,
The
and
Indian
you
landers.
read everything, the
Yep.
land description, what they're gonna do, how they're gonna do it, everything's on that paperwork. If you disagree, you can go in there and say, I'm not signing.
The difference is, though, the the bidding has already taken place.
Yeah,
By the
that's
time you
right.
guys are notified whether to accept the bid or not, you're just presented with the information that winning bid gave.
Well, I've also heard that BIA, when they do the bidding process, they don't get the highest bidder. They get the lowest bidder.
Well, their buddy's better.
Well, I mean, I can't speak to that, but I can speak to the fact that this is what we're talking about. Yes, I mean, our landowners, I mean, sometimes they'll give you a sheet to sign and say whatever, but in the end, it's the Bureau of Indian Affairs who has that decision. And you guys get the lease document, the lease notification at the stage where you guys can disagree, as our landowners can disagree with that, after they've already taken all the bids. I mean, you don't know if that bid is a fair market bid. I mean, you don't know if there's other bids out there that were higher or.
Well, you've got rights to go in and ask.
Why not have an open bid?
They've always done it for years
Yes.
like that.
Okay.
Thank you.
Ransom. Has the tribe aware of the Heart Act?
We're aware of it, yes.
Has the council considered the possibility of writing up some regulations where the tribe can do their own leasing and literally take it away from the Bureau? It would seem to me that, one, Sammy, if we had a realty department, that we had the expertise on hand, we could go out and do our own leasing.
Absolutely.
There's our documents under the Heart Act that we have to write up and submit them and get them approved, and they have to follow NEPA and all the other environmental requirements, and they have to be consistent with the BIA requirements. But if you can get that approved, you can move that function from the Bureau of Government over to the tribal government. And these type of things where our tribal members then want to know about, then you can go and implement where you can have a one-on-one with your tribal members to make sure that they are agreeable to whatever the lease requirements are. And if they're not, then perhaps as the agent for that tribe, stepping into the shoes of the federal government, we can say, oil company, we are not satisfied with this, can we negotiate? So I think it puts more power into the tribal government.
Yes, and we are working towards that. That's kind of the end goal here as all this. But you know, again, in order to do it, myself, because my job is to ensure that anything we start is going to be successful and sustainable. And so I want to make sure that we know where all the funding sources are going to come from to support the positions necessary, because it's one thing to fill those positions, right? It's another thing to have people who are experts or knowledgeable of the process in those positions. And so we have to make that position attractive to people with that knowledge base. And so in order to do that and make it an attractive position, we have to be very deliberate in how we institute a new department within the nation, or a new division.
I think that the seed part of that's going to come from the land buyback.
Yes.
Because we're going to have an office here, and for that land buyback outreach, and I think that will seed into a realty department. That's the way I look at it, anyways.
I appreciate that. I think that's a good way to go about it.
Right. I think the money is $500,000 once
we
get to the top of the list, and right now we're like midstream. We are not a priority because of not really the Otos with your 400 fractionated lease, but the Ponkas are done now. I think they're up north in North Dakota right now, trying to get that all settled down, and then we're going to be approached by them, I would say at the end of 16.
Do we have a plan in place so we'll be prepared when that comes available to move right into that?
Yes, we do. Yeah.
Thank you.
Yes, Mr. Bird.
Seems like you have a lot of difficulties talking to the BIA. I don't know, maybe it's because I'm an individual landowner on my land. Now, I know people down the road, there may be 120 people on that piece of land, but they're going to have to talk to every one of them.
And we do.
And they all agree. It's kind of like our lease on our casino land. It's kind of hard to get that, everybody together on that, But are you guys dealing with any other nations on these things, on the environmental parts or anything?
Oh heck, we just had the Osage down here. They want to establish their environmental conservation. They want a ranger program, and the model ranger program in the nation. I don't care. Honestly, I don't care if it's on the federal side, state side, or Indian side. Is here in Pawnee. I mean, those guys are, what they do and what they've been trained to do is phenomenal. So we've had Osage here. We've had all kinds of interest from the Cherokee Nation. I've been to a few. Actually, Don's been to more than I have. Environmental commissioners' meetings at Cherokee Nation. I mean, yeah, whatever we do here, we know we're not doing it in a vacuum. I mean, we know that there's 39 federally recognized tribes in the state of Oklahoma, and that we all have a voice in what happens to us here.
And I really tell you the truth, I really appreciate it. You know, from being a guy that fought Black Fox, if any of you all remember Black Fox in Oklahoma, we stopped nuclear power being in Oklahoma. And I appreciate y'all stepping up and all this kind of stuff, because it's just a tip of what's going to go on now. Stuff in the Standing Rock and Colorado River and the Snake River, and you know, we saw Missouri blow up. The land just started burning.
Yeah.
You know, it's going to be a wow.
And Mr. Bird, I don't want to mistake it. Our position against our attitudes against the BIA and BLM are not against the individuals.
No.
I have great relationships with Jeremy Lovecamp and all the employees there at BIA. What we're talking about is a systemic issue, an issue of...
We're talking about accountability to somebody that's supposed to be
correct.
Working for us. You know?
Correct.
Yeah, that's all it is.
And it's not
wrong with that.
It's not the superintendent's fault that you know he doesn't know exactly. Well, no, he knows, but it's not the superintendent's fault the way things work out. It's the policy that's in place that help guide him make his decisions or her decisions on a daily basis. You know, that they're just following policy. That's what they do.
Well, their awareness is going to get a lot more aware.
It should.
That's what counts.
Yes, sir.
So, as you stated that educating our tribal members, you know, about their land and, you know, about what's going to happen, is there any way that as a tribal land owner that they could personally be involved in that litigation process so that they are not just, here it is, you can accept this or not, they actually know, hey, your land has been prospected, it's under, you know, review for this, would you like to attend these meetings, because that way ultimately you are educated on what will happen with your land?
There is actually that's a good question, because within our lawsuit that we filed, we have built in you know, provisions to where if there are individual allottees that are affected by what we have, and we're very narrowly defined it to what Francis EchoHawk.
That's right. But
Gertie Curly Chief.
Yep. Yeah. But he alludes to the bigger point. The bigger point is that's what we're wanting from BI and BLM, is that all someday, hopefully in the near future, all landowners need to be noticed. And they need to have an opportunity to be heard. Right. This isn't rocket science here. This is due process and equal protection.
Right, but as you and I both know, there's not much justice in the judicial system.
Well,
the
thing is you got to play. I mean, this is the system we have, and so what you have to do is do the best you can with the system we have. Right. If you have problems, you got to address it.
And I understand the need for fossil fuels, but I also understand the future effects that it has on, you know, not only our area. I'm actually from Skytruth. I go over from here. I live in Osage County, the wool capital of Oklahoma, amongst the Osage people. So I know that, you know, they have that passion. But and another thing is like the BIA, I may be wrong, but to my understanding that the BIA was formed so that we could adapt these processes and run our tribe ourselves. Why in 2016 are we still dependent on BIA?
Because the BIA has made it difficult for Indian nations to achieve, well, not just the BIA, but the federal government.
The U.S. Congress
has made it difficult for Indian nations to achieve that full independence. Now, there are mechanisms for it, and the nation is working towards some of those mechanisms to get to self-governance. Is ultimately where we want to be. But again, that takes resources, and those resources, right now, we're a direct service tribe, so most of our resources come directly from our federal government.
So we're not sovereign, we're not a sovereign nation.
We are sovereign.
In a word that maybe loosely people like to throw around, but in actuality, legally and definitively we're not a sovereign nation?
Yeah, I would probably say that we are right now we're about as sovereign
Transitional?
we're as about as sovereign as the state of Oklahoma is. I mean, the state of Oklahoma really isn't. I mean, if you think about how sovereign they are, the federal government tells the state of Oklahoma what to do. I mean, the federal government ultimately is probably going to be able to tell.
I'm
Yes.
going to answer that. I'm sorry. We are a sovereign nation, but we're dependent on the federal government's resources. But we are a sovereign nation. We've got to get things in order within our tribal government in order to achieve self-governance to where we can operate our own programs, our realty programs and things like that. But we've got to achieve those things financially and audit-wise before we can even seek that. So, but we are moving towards there, and I'm hoping by the end of my term that that's where we'll be.
Right. And I understand and you heard what you said. Sovereignty is not relying on any outside source for funding. So whenever we rely on any government funding for our claimed sovereignty, then we are not sovereign.
I disagree, but I don't want to debate that because sovereignty to me is our culture, our heritage, our land, our language. And unless we give that up to whoever, then we are sovereign. That is what true sovereignty is to me. It's our heritage, our culture, and also providing those resources to meet the needs of our people. But we've got, in order to get there, we've got to have certain things in place, like revenue-making enterprises, in order to switch that transition from federal resources to tribal resources so that we can be 100% sovereign, where we meet every need of every tribal member with tribal resources and not dependent upon the federal government.
And I agree with that 100%, and that is sovereign.
And it should be also noted that you know, I meant what I said. I mean, we're as sovereign as the state of Oklahoma is. I mean, the state of Oklahoma, they rely heavily on the federal government on subsidies for roads and transportation and health. And if the federal government cut off the funds to the state of Oklahoma would be in trouble. I mean, they wouldn't have the money to support education and infrastructure development.
70% of the budget.
Yeah, it's about 70% of the state of Oklahoma's budget is federal funds. In that sense, we will always have that federal assistance. The difference between the state of Oklahoma and us, which makes us more sovereign, in my opinion, is that our funds are given to us by the Congress, apportioned to us by the Congress, not because they want to or they feel like it, but they have to, through treaties. So we're different than the state of Oklahoma.
Every treaty that has ever been made has been broken.
We understand that. We understand that.
How about as something maybe to consider, which is outside the spectrum of, you know, the fossil fuel, but as something that could produce a revenue for our tribe as a sovereign nation, at every entrance into our Pawnee Nation, we have a toll booth.
Yeah, we were talking about that. That's why we're laughing, because we were talking about that.
You know, you want to come on our land, you pay.
There was an instance where the state of Oklahoma is building a bridge or redoing a bridge, and they just decided on their own, hey, we'll just reroute the traffic through the Pawnee Nation. We're like, wait a minute, you can't really just tell us to reroute the traffic because our roads can't tolerate constant semi-trucks and all that kind of stuff. So we were talking about, hey, let's put up a toll booth. Anyway, we'll conclude with that. I want to thank everybody for coming out, taking the time to come out here and get educated. And again, if you have any questions whatsoever, feel free to come and contact myself or probably any of my staff, and we can answer that question to the best of our ability. If I can't answer it, I'll find you an answer or find you somebody who can.
One final comment, the last word.
I know I got the microphone up, guys.
I appreciate, Andrew, you gave a very good encapsulation of beginning this, what we're all about. Council, thank you for stepping up. Pawnees have made a giant step forward for all tribes in the country by filing this lawsuit. Thank you for being proactive. So I just wanted to tell you that things aren't going to always be good. You're not get everybody to agree with you.
But I want to say thank you, and please continue to go in that direction for our people. We want our people at the table when we make decisions. We want our people at the table when they sign their leases so that they can be okay with those terms and conditions of that lease so that they get what they're deserving out of that. And it's not absorbed by some 50-year-old lease that's been on the books for 50 years because the Bureau will not step up and do their trust responsibility. But the bottom line is, it's a sweet one. Thank you. Good on.
Thank you.
One more.
You want one more? Maybe I can
This
give
is
one more
just an
without losing. Yeah.
It's an input. I'm a licensed real estate agent, and I actually have, I would say call it the pleasure, but I deal with the BIA for Osages who own restricted land, and I've taken out the restrictions for these people who are constantly under the thumb of the leases, hunting leases, cattle leases, oil leases, and so we started the rhetoric, and they were like, what do we do? And I said, well, let's put something together and go to them and get the land out of restrictions, that way you can do with it what you please, and we've done it.
Yeah.
So it's possible.
It is possible.
But it's dealing with the BIA, so you're so much better off if you have a realty department through your nation, because the
She's
BIA
one of the
is terrible
best.
picking.
Yeah, we understand.
So, it can be done, so I commend you to go on that path and seek it. Don't give up.
Thank you. Well, again, thanks for everybody for coming out, and I hope you have a blessed evening, and we will keep you all informed. If anything happens, anything, we get any word on a lawsuit, we'll make sure to post it. So have a great night. Thank you for coming out.